All right, this is the case of People versus Desiree Yagan. We'll note here the appearance of the defendant who is appearing pro se. This case is on our calendar today for a trial. Ms. Yagan?
Yes, may I put something?
Sit right here at the table. We have a letter dated October 10, 2006 from Assistant District Attorney Geoffery Cireck. Do you have a copy of that?
From what date?
Geoffery Cireck from yesterday?
No, I don't.
All right. Here, I want you to read it, if you would. I'm going to go off the record for just a second. If you want
Do you want me to go make a copy of it?
Yeah. We'll note here the appearance of the defendant pro se, and we've just been off the record in order to afford the defendant an opportunity to review a letter memorandum dated October 10, 2006, signed by Assistant District Attorney Geoffery Cireck, wherein based upon his consideration of all the pertinent factors involved, he's lodging a motion to dismiss this case in the interest of justice, and he's also indicating that they're waiving their presence here in court today, unless the court finds some reason to find their presence necessary. So have you had an opportunity to read this letter, Ms. Yagan?
I glanced through it, and this says, first of all, I just wanted to say that this was totally unexpected, and I was focused on one issue. Now I have to reset myself, and now I perused through this. I didn't read it carefully, but it's clear. It is they made the motion to dismiss in the interest of justice. Your Honor, I contend that in the interest of justice that we must proceed to trial. If the court will note that affidavit of prejudice was filed September 8th at 3:43 with the Syracuse City Court, and it's 30 pages. And the purpose of bringing attention to the court is in this very comprehensive 30-page document. I stated in there, and I have to look as I speak to the court, that under no circumstances should the attorney be, hopefully it's in this one, I've stated repeatedly, under no circumstances have the district attorney's office prosecuted me since July 21st, well, after they received the case. If after they prosecuted me all that time on a inane staple gun incident, that was my assertion is a overtly false arrest, and put me through the trauma and the time and the agony of appearing before the court and having to endure the distress, and also the false imprisonment held down when I was arrested for the staple gun incident. Your Honor, I assert that in the interest of justice, we must proceed to trial. I stated in the finding it at the moment, but I distinctly state, it might be in a text box, Your Honor, that under no circumstances should the district attorney's office now make any offer to dismiss the case, because it would deny me the right to prove that prosecution by the DA was malicious, Your Honor, that it's been the intention is to protect the sheriff deputies from civil liability for a false arrest, and it's a continuation, Your Honor, of the malice by the district attorney's office due to my charges of false arrest and malicious prosecution of the July 16, 2000 arrest, where they prosecuted me for 22 months and then dismissed the case. Then the case was dismissed before Judge Christopher Geiser on May 9th to the day before my trial over my strenuous. No, I wasn't dismissed at that time. I'm sorry. James McGraw was allowed to withdraw the day before my trial when I refused an offer of dismissal that was not exoneration, Your Honor. So we have a history here of the DA prosecuting me, putting me.
Before we get to the merits of this letter application from the people, and I just shared it with you because I like the record to reflect on, so that I was out of town just and out of the office, and I was not aware of the contents of this letter until this morning when I had a chance to review it. Apparently it came into the office yesterday sometime. Nonetheless, we had also pending in this case some papers that you